Okay, so what we're going to talk about today is what you wish your kids or executor knew about your plan. Before we start that, I should give you a couple little warnings about this. I believe we're taping this. So if you raise up your hand and have a question that's very personal, right? Mark, my no good son-in-law, how do I get him out of my daughter's life? Or my daughter is just going crazy and her name is this, we may have that on tape. Well, by the way, there are a bunch of other people here too, so you probably wouldn't want them to know, but just be aware of that. If you ask a question, I'll probably try to address it during the seminar, but if it's something private, we may need to have another place for that. Does that make sense? All right. Now, the bottom line is, why even choose a topic like this? Normally we come out and I say, here's what a will does, here's what a trust is, here's what the estate taxes are. And because you probably came expecting me to say things like that, I'll mention it, right? I'll talk a little bit about those things. But the main reason I thought this might be a good topic is I found there's some things, some questions I get asked over and over and over. And as people are telling me, Mark, this is who I want to serve as my agent, or this is who I want to be my executor or trustee, they're starting to wrestle and grapple with these questions. Not only who is going to serve, but what do I tell them? How can I communicate to them, and what should I be telling them? Should I tell them that they're my agent? Should I be telling them more than that or less? And you get enough questions, 10, 20, 30 years worth of questions, maybe it's time to answer them. I don't know, right? So we can think about that. That's the main reason for this topic. Now we are going to follow along up here, but this is way too small for me to read, let alone you in the back row. So the bottom line is you should, somewhere in this handy-dandy pamphlet here, with this unbelievably handsome logo, very similar to the Rainier's or the Rainier Beer logo, just a coincidence, right? There should be inside that your own color copy version, which I will be willing to sign later at my event with Taylor Swift later on. So you could follow along with that if you would like to. Now, like any seminar, I need to have a warning, and the smaller print I can put it in, and the more words, the better, because that gets you used to working with attorneys, right? The bottom line is you need to understand this. This seminar is just general information. If you go home and go, aha, I know exactly what to do, I'll do this, right? That may not work, because everything is very specific to your situation or your needs. So frankly, this is more or less for you to start considering things, and then if you want to make changes, either with us or some other firm, somebody, you want to reach out and coordinate with them to make sure your specific needs are addressed. All right, so we have a few more coming in. We have 2 seats right up front. You'll be right on camera the whole time, or there may be ones in back. I'm sorry. They were looking for the deli. The other thing, while I'm on that, grab some cookies if you haven't already done that. That was the way for us to bribe you into actually showing up. Because otherwise I get sad when I'm here by myself and I have 48 people say they're coming and I'm just standing there to an empty room. But the bottom line then is, right, don't take this all as if this is legal advice specifically to your situation. The preview is here. We're going to cover each one of these things in turn. The bottom line is, right, what do I want my kids or executor to know? Maybe you only want them to know the bare minimum. I really am not comfortable with them knowing a whole lot more. I just want them to know the absolute minimum they should know. Well, wait, what is that? What's the minimum they need to know about? Maybe you want them to know what to do in the case of an emergency. Something happens to you. They get a call from the hospital, or they get a call from the police. Something's happened to you. What would you want this person to know? What information could you give them? We may also say, well, I've actually put my kids or someone in charge of my estate after I'm gone. They're going to administer it. Some people would like them to know a little bit more about what that means. Either A, because they're going to go, wow, that's way too much work. I don't want to do that. Mom, Dad, can you pick somebody else? Or, right, they're like, oh, that's what I needed to know, right? I need to have a big picture, so the first thing that they do after you die is not panic, right? They have an idea of what's supposed to happen. And sometimes a little information will go a long way. A number of people, not a ton, but they also just, hey, they want their kids to know something about their plan. What is it about your plan that you would like to have to communicate to people? And then finally, we're going to talk a little bit about, well, what if you really want to kind of give them the full meal deal? I want my kids to know they're included in things and they're very comfortable about what's supposed to happen and when. Again, if you do have questions, raise your hand during it or kind of shout out. We're going to, move on to the next slide. Obviously, everything I'm saying is if you think they can handle it, right? You want to make sure that you're not telling your little grandchild who's 2 years old, this is what happens and go look for my will, right? Anything like that. You want to make sure that they, have capacity. Maybe you're on speaking terms with them. They haven't been estranged for 30 years and out of the blue you're telling them this. So you got to make sure. You want to make sure that your goals, right? It depends on your goals and your concerns about the situation. So you're going to be the one who kind of takes this home and decides, again, what if anything should I tell my kids or my executor about my plan? So let's start with the first one. Well, what if I only want them to know the minimum? I don't want them to know anything that's private. I don't want them to know where my stuff's going or who's getting it or anything like that. What is the absolute bare minimum I should be telling people? So the first thing that you will want to let them know is that you have an estate plan, right? If they don't know that you have a will or a living trust or other documents, they're not going to know. And then something happens to you and they're running all over the place going, I don't know what they had. What have you done? Panic, right? Immediate panic because they're looking for the documents, which means most of you should have a binder that looks something like this. A handsome dark blue faux leather binder. You can treasure that, keep it carefully close to your heart. And some of us think this is so valuable, so amazing of a binder, that they put it in a safe deposit box. You do not want to do that. Why not? Because if there is an emergency, your documents are in a safe deposit box, they can't get a hold of it. It might be a weekend, might be a holiday, might be after hours. So you want to put your binder in a place in the home that your kids know where to find it, which generally means bookshelf. It might mean a filing cabinet, a safe if they can get into it. I'll have many people say, well, Mark, what if it burns down? My home burns. What happens to my documents? We keep a duplicate original. So we should, Lord willing, we should have a duplicate original of your documents if for some reason this goes missing. I will often use the, fire, flood, or the dog eats one, but we've had a lot of floods lately in the States, and a lot of fires. So those aren't quite as off chance as otherwise. But that means you can probably leave this binder in a place where people can find it. We're going to look through some parts of the binder, and in fact, you're going to see here and there where I have a tip for you often in your materials. So when you go home, you want to pull out your binder, right? And you want to look at it, and you're going to see some places where I have a tip, and you're going to go, oh, look at that. I didn't even know that was there. And hopefully, you will then think about some things you could do to put more information in the binder other than just the documents themselves. But for now, the main thing to know is where is it, right? Where can they find your estate plan? and they get a hold of it. One thing that we do as well is when you sign documents, we'll give you the opportunity to have an electronic PDF scanned copy sent to you. So sometimes many of you may have that electronic scan copy. You may want to provide at least a healthcare power or something like that to your agent under your healthcare power, things like that. So the first thing then, do you have an estate plan, and well, where can they find the documents, right? Where are they? You may also want to at least single out or let everybody know, here's who my agent is under my power of attorney. Why? So everybody doesn't run to the hospital and start fighting about who's in charge. You may have more than one child, and you have been telling them for years to stop squabbling. But if you're not there physically, or you're not able to communicate, all those things where everybody deferred to you, boom, it's all going to come out. All that squabbling. Now, I will give this seminar, and I'll often talk about this happening. A few years back, my family got together for Christmas at my mom's. My wife and I were the only kids that year. We didn't go. We had other things we had planned. We couldn't go. And basically, the day after Christmas, I hear how there had been this storm of eruption at my mom's house, ironically, essentially centered around her estate plan. Now, thankfully, this is in Georgia, right? I didn't cause this problem, but right, this can happen to any family, and it often will happen during a time of crisis and grief, because emotions are running wild, and you're not there to tell them to stop it, or you'll turn this car around, or you'll stop the car and swap. You're not able to do that anymore. So you want to let people know, especially the person you've named, because otherwise they may not know. Something happens to you, like, oh, I guess my older brother will be taking care of everything, and everybody's just sitting there waiting for somebody else to take action. So you want to let the people you have named know, look, you are the person if something happens. Now, most of you in your documents probably have listed more than one person, right? If my spouse is living, then my spouse is in charge. But if they can't do it, then this person. If they can't do it, then this person. When I'm saying let people know, you're probably looking at the first person in line, or if you're married, the first person after you and your spouse, if something happens to you both. Yes?
I was talking to my daughter the other day about something that had to do with the insurance policy.
Right?
And I said, I know we've already talked about this before. And she said, we probably have, but I don't think I was listening, because I don't like listening to those things. So
right.
Even though you've had the conversation, they may have already put the wall up without knowing it, and
yeah, absolutely.
Don't remember. Yeah.
That is a great point. The comment is that, you know, there's a conversation with a child about life insurance, and here's the beneficiaries and things like that, and the child says, whoa, 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 I don't want to hear that, right? Mom, you're always going to be living. You're never going to die. And that is a common reaction. Understandably, and we felt it ourselves when our parents were around, or maybe they're still around, we feel it now. We got to understand that's a natural reaction. But we still need to make that communication. I understand that. Thank you. I'm making every provision not to die. But in the highly unlikely event that happens, right, I want it to go as smoothly as possible for everyone down the chain. Okay, so then, we probably are all ready. Oh, here we go. The next is, who's the attorney? Now, what a selfish thing to say. Mark, you are unbelievable. I can't believe you would do something like that to try to shill yourself off on my kids. Well, there's some truth in that accusation. But on the other hand, what a great thing for them to know. If something happens and I don't know what the heck's going on, or I can't find the documents, these are the people that help put it together. They can walk your next in line through the process. So you probably also want to let them know who's in charge, right? And who the attorney was. Now, if your kids the next day call me up, yeah, here's the attorney, if something happens, I need you to, reach out. They call me up the next day and they say, Mom says you're the attorney. What's going on, right? I demand to know what I'm getting and when. I gotta go, whoops, you're not my client, son or daughter or whoever. I can't talk to you without that other person's permission. So make sure they understand that that doesn't mean they have carte blanche to just call us and demand information. It means if something happens, an emergency occurs, we will have people call us out of the blue and they'll say, I'm Mom's power of attorney, this has happened, I need everything right now. Many times we still have to get more information from that agent under the power of attorney because people can call and say anything, right? For example, I have won a large amount of Nigerian dollars, right, just by giving them my credit card and banking information. So they can basically call and have all kinds of stories, and we have to vet that. You may want to let them know what other advisors they should contact. Now, believe it or not, I know this will come as a surprise. Believe it or not, our name and contact information is on almost every document we provide. I've been talking to my team, and I would like us to start having a small tattoo parlor in one of the offices, so you could also have that put on, right? Oh, look at that, Contact Rebirth Law Group. But that actually is only us. There may be other people, financial planners, insurance agents. Maybe you want them to make sure you have a person of faith they need to contact. Maybe there's other people in your world that you want to make sure that they know about because law is kind of one piece of everything. Maybe there's some CPAs that they work with often, right? You want to make sure that they have that information just in case. Because getting all of that help toward the beginning, all that information at the beginning, will lead to a much, much, much smoother process down the road. All right. Then finally, you're going to hopefully, I'm talking about the minimum. I know this seems intrusive. You want to let them know where the information, the statements are. Even digital information. A lot of us have online banking or we have online accounts. We have various kinds of things, even just our LinkedIn or whatever account we've got. It is probably a good idea, even if you're not giving it to them immediately, you're letting them know how they can access it. Your documents will say, I give my agent under my power of attorney the authority to access my digital information, or my executor has the authority to do this. But if they don't have the password and they don't even know what's there, heck, half the time I can't even get into my own accounts because I forgot my password, right? Honey, what's the password to this? So you want to let them know. Many times, I don't have a great way, by the way, for you to give this to other people because any way has its own risk. Some people will have a document that's password protected. Some people have password management systems. Some people have thumb drives that are password protected. Those kinds of things, you're trying to find out what you think is the safest way to provide that. Yes?
If you have income producing property of the state, okay, then so you appoint somebody to handle it. Okay. Do you need also an attorney besides an accountant?
The question is, if you have income-producing property in another state, do you need an attorney as well as an accountant? During life, you may not need a separate attorney for that. It depends on what's happening. Obviously, if there's a dispute, a county is arguing about something, or the neighbor's tree fell on the lawn, sure. But in the normal day-to-day event, you may not, right? If there is one, somebody who set up an LLC in that state, it isn't a bad idea there too to let people know. Now, gee, Mark, you thinking, that seems like a lot. Where am I going to put all that information? I wish there were a convenient way for me to provide that information to my next in line if I needed it or they need it? And the answer is, we have that for you. There is a tab in your binder which is going to be under the important information tab. And you'll see this down here in your notes, right? And it has all kinds of blanks for you to provide to people to say, here's the important people to contact. Again, of course, we list ourselves. We don't want you to work too hard on that one. But there may be other people that you think, boy, that would really be helpful if they knew. There's a property management company for that property in another state, and you're dealing with that property management company. You bet that would be helpful to know, right? So, because they're going to need to reach out and go, hey, this is what's happening, okay? So, the other thing that you may want to let your next in line know, not just those types of information, but many of us have our own ideas about what we would like to have done with our bodies after we're gone. We may say, I want to be buried. We may say, I want to have a Viking funeral. We may say that I want to be composted, right? It's up to us to a degree. But in any event, you want to let people know what you've decided. Those things should be in writing, especially if you don't want to be buried 6 feet under in a $42,000 walnut, casket. You want to make sure people know what you want. And if you've already made those arrangements and people are like, what the heck is composting? You've already made that arrangement and they can look in your materials and go, oh, well, let's call them. Why is this a big deal? Because if you die in a hospital, the hospital will ask whoever's there, within 24 hours, they want your body out of the hospital. Now we've got someone in grief and exhaustion and bewilderment trying to make this decision in minutes. And that's where we end up with things. And meanwhile, more than one child may be there. Everybody has their own idea about what you wanted. Again, there is a place in your binder, and you'll see that under the tip. That is under the instructions, the burial and funeral instructions in your binder. There's all kinds of pages there. What you might like, if you want cremation or other things, but if you have your own plan, absolutely. You want to just maybe 3-hole punch it and pop it in, or get a copy, let them know where is the contact information and the arrangements you've already made. Basically, where is it, that you have a plan, who are the people to contact, and then some of those ways that they can find out what kind of assets, how they can get, even knowledge about where are the accounts and things like that. Any questions on that? Okay. How many people have done that? Good work. How many people are willing to admit, Mark, I've been a little busy, right? So, right, strongly consider this. Believe me, your kids will be very thankful. I have met with a number of clients, children, and I say, how is everything? How you doing? I'm sorry to hear what's happened. And they're like, wow, mom or dad had really things put together in that notebook. So far, it's been pretty smooth, right? So that can make a big difference. Okay, my help is back. And so we're going to turn to number 2. Right now, we've got the minimum. That's the bare minimum. We've done it. Half of you leave the room, the seminar at this point, because you're like, that's all I'm doing. Some people might like to do a little bit more. And it can help a lot if you let your kids, your executor, essentially those people in charge of things if you can't be, if you let them know what to do if there's an emergency. Because they're going to get a call out of the blue, right? Hi, this is nurse so-and-so at the desk at this hospital, or this has happened, or, hi, I'm the neighbor, and it looks like your mom is having some issues. This is a problem. Who's supposed to be doing what? What is it? What's happening? They race to the hospital. Nobody knows anything. So you say, well, Mark, I've got a healthcare power of attorney. It's a spectacular, beautiful healthcare power of attorney. It even has the saintly words Rayburn Law Group on that healthcare power of attorney. What could possibly go wrong? Well, what might happen is nobody really knows who's supposed to be racing to the hospital or who's supposed to be making decisions. So again, you want to let people know who's in charge. But you also want to let people know some other kinds of information. What if you have allergies to certain types of medication? What if you're on certain medications? What if there's certain procedures you say, I would never want to undergo that? Or, you know what, I'm okay. This is fine if they need to do this. These are all extremely personal decisions. How are your kids going to know that? It is not unlikely that they're going to all come into the hospital and go, boy, I was talking to Dad one time over a beer and he said this, so I think we should do that. And the other person says, well, I talked to him yesterday and he said this. And each thinks they are right. So you want to let them know, not just who's in charge, because your healthcare power says, basically, I authorize my healthcare agent to make any and all healthcare decisions for me, but it doesn't list what they are and how you would choose in that way, right? Do I want a new kidney? Yes, no, right? And do I want a blood transfusion? Yes, no. It's going to let them make that decision. And the first thing when they charge into the hospital, I'm here, I've got the healthcare power of attorney, I'm here to make decisions for my mom or dad, and they're gonna go, okay, we need to know right now, do you know if they're on this medication? Because if so, we can't do this particular thing. Are they allergic to any of that? What? I don't even know if they're on Medicare supplement. I have no idea, right? So you want to let them know that. And believe it or not, there is a tab in your binder that would allow you to put down that kind of information. Staggering, strange, but true. And that is under the healthcare power of attorney. There should be, either in front of or in back of your healthcare powers of attorney, a section called Important Healthcare Information. You may want to consider filling that in, right? It has pretty good information. Who are the physicians, right? Who are the specialists? What are you on? What can't you do? Who are your agents and how to contact them if something happens to you? And then it's not a ton of room, but it says, what are some treatments I would or would not want, right? These are things, there's no way I wouldn't want this, don't do this. That can give them a lot of guidance in a time of intense pressure and emotion that will be beyond benefit to them. Well, we also need to know what would happen if you are incapacitated, right? Not just what happens if you're in the hospital, but if there is a long-term mental incapacity. Alzheimer's, dementia, something happens to us. We're no longer able to make decisions for us. There's sometimes a lot of confusion about what is it people may like or even what to do. There's a slight concern, sometimes your agents don't really understand your documents. How could they? Right? This is probably the first time they've been seeing that. So you need to kind of maybe think about, or should I mention, if I've got different people in charge, you're in charge of the healthcare, but I put your brother in charge of the financial stuff through the power of attorney. So they don't, well, no, I'm in charge. You know, I get to decide what mom does in the hospital. No, you get to decide what we're doing with the money, but sister or other brother or somebody else is in charge of those healthcare decisions. So you want to let them know that kind of thing. And the other thing to know is some of you may have a power of attorney that's effective only if you become incapacitated. In other words, there probably will be some big lines on it that say this power is effective upon my incapacity, right? Which usually means it's shown by 2 doctors' visits, right? Where 2 doctors, 2 physicians say you no longer have the ability to manage your affairs. That would be helpful for people to know about, because otherwise it can cause great frustration. People are like, well, I'm taking care of Dad's finances, and they bring that power of attorney to the bank, the title company, whoever they need it, and the person's reading it going, yeah, this isn't effective. And it can take a while to get those doctor's visits. What does it take you to get your own primary care visit, right? 6-8 weeks? You know, well, we can fit you in, next election time. But to get 2 doctors willing to have that, to make that determination for you can take quite a bit of time. And if you become incapacitated, we're kind of on board. Now, that's with the power of attorney. I know for most of my clients, unless you told me, right, Mark, I specifically don't want this to spring into effectiveness unless I am incapacitated. My usual approach is if you trust people, make it effective immediately, right? They could, yes, they could go to the bank and drain your account the next day, but we trust them, so we know they're not going to do that. I once had a woman come to me and go, well, Mark, I'm going to name my oldest son my agent under my power of attorney, but I just don't trust him. What should I do? Don't name him, right?
Yeah.
Don't name this person that you don't trust, regardless of their expectations. Did you have a question? Okay. All right, so then you want to let them know your wishes regarding end-of-life decisions. Yes, of course, your healthcare power is going to give people authority, but your directive to physicians, often known as a living will, that will do that as well. However, I want us to think for a minute. Those are pieces of paper. They're written down, and they're incredibly important and helpful. But life is complicated and is a series of gray. So we need to, if possible, also let people know, look, I have a directive to physicians. I don't want to be kept alive if there really is no hope, or I do, right? Let people know what you want so that they're not in a panic and arguing with the other siblings about what's supposed to happen. And because that way, when everybody comes and meets with the doctors say, I'm sorry, there's nothing we can do. That way they can go, here's the healthcare power, and everybody is on board. They understand what it does and why you're doing that. It's just a way to have a relational backup and conversation about this before people pull the document and go, what? That isn't what Mom would have wanted, right? So you want to make sure they understand that. For many of your documents, by the way, you can provide those, and in fact, they're going to constantly ask you for copies, right? These days, you can either bring a copy in and go, here, put this with my charts, and through the Electronic Medical Records Act, that can often be shared from one place to another. And nowadays, you can also upload them to things like MyChart, right, which will then be available. So even if your kids can't run into the house, find where you put the binder, race to the hospital or wherever they need to go. This way, it's already there. The hospital already knows a lot of the information about who's in charge. Yeah.
The last seminar that we had with Ryan, I think he said something about the living will, not to give them a copy of it until they absolutely needed it.
Yeah.
Am I remembering that correct?
Yeah, some of my clients are a little worried that maybe the doctors will, push the do not button too early. And they're like, look, I really want my kids to be absolutely confident there's no hope. And then, yeah, so some clients will not provide the directive immediately. They'll say, kids, here's where the healthcare directive is. Keep it handy when you're convinced there is nothing that can be done right then here, right? Yeah. Okay, there's also for many people a HIPAA privacy release. I've started providing that maybe the last 5 years. Basically, you come in for other documents. I put this one on as well. That is a release document that gives the doctors comfort. They're releasing your private medical information. Here's who they can provide it to so they can make good decisions. Yeah?
I once worked in a health facility, and one of the things was if people were taken out in an ambulance, they're not going to sit there reading through these documents.
Oh, yeah, exactly.
So we had, first it was a shortened form DNR, and then
A pulse form? Yeah.
Now, should we have that also with our doctor?
The question is, which is a good one, look, let's be realistic. You're lying on the floor. The EMTs come in and find you, or the ambulance is racing you away. They're not gonna go, hey, pull over for a few minutes, I need to read this. The ambulance is bumping too much, right? And I'm not certain what this word means, these lawyers put in, let me Google that. So, because every minute they do not work on you, you lose like a 20% chance of recovery, right? So there are many short forms, many other forms that people use. One of them is a DNR, a do not resuscitate. Another one is a pulsed form, usually bright green, physician's orders for life-sustaining treatment. Generally speaking, those are a yes/no box, right? Yes, I want this, no, I don't want that. It would include more than your directive to physicians. Typically, the directive to physicians is there for those end of life, you're in the hospital, and now the doctors are agonizing about, can we take measures or not? And the reality is, there is a statute for the directed physicians, and the statute specifically calls for such a thing to be there for two reasons. One, that if the doctors follow your directive to physicians and you die, they are not liable for your death. So doctors often want, if you're stabilized, they're going to want that healthcare directive before they feel comfortable. Number two, we don't want anyone to think that this is sort of an assisted suicide or a murder. And in the statute for the healthcare directive, it also says health insurance companies cannot use this as a way to deny coverage. So the reason for the healthcare directive is very statutory. These can work together. Many people will put a pulse form on their refrigerator or somewhere where if they find you in the house, first, 3, 4, 5 minutes, they can use that. Yes, I do want CPR, no, I don't. Yes, I do want a blood transfusion, no, I don't. But when you're in the hospital and stabilized, but unfortunately there's no hope, death is imminent, 2 doctors will certify that, or you're brain dead, no hope, that's when the healthcare directive tends to come into play. Thank you, great point. Okay, so, again, I pointed out the TID, your important healthcare information, HCPOA, that's my lazy way of saying your healthcare power of attorney tab in your binder. So again, you go home, you're like, oh no, there's more things to do. Look on this page. I'm going to go to that tab and consider filling that out. You may want to put it in pencil, something erasable. You see me in all of my meetings, I use a mechanical pencil, not because I'm a draftsman, but because I realize that eraser is a godsend, right? So many mistakes I can just erase out as if they never existed or things change. Okay, any other questions on that? Number 3, I want my kids to know about the process of administering my estate. We are really now moving into the area of how much do you want them to know about? Why would I suggest that you consider this? This is great. It's a little macabre. Why would my kids want to know? They don't even want to know about my insurance, Mark. They don't want to know about administering my estate after I'm dead. The answer is because many times I meet with kids or executors and I will start walking through the process and they are dumbfounded. Probably just like you were when your parents passed away, or the first time you met with an attorney and they're like, no, actually it kind of works like this other way. You're like, that makes no sense whatsoever. And as Dickens said, if the law says that, the law is an ass, an idiot, right? But many things, the law says it must be done in this way. And so you may want to let them know, here's why this is important. Again, what we're trying to do is give people enough information they don't panic, right? The last thing we want is information overwhelm after you're gone. I will meet with some kids or some people after someone has died and it's months later. They don't come and see me for months. I'm like, what's happened? They're like, Mark, it's just been too much. And I have the unpleasant task of telling them, we've already missed a number of things and deadlines that we were supposed to be handling. Oops, right? This is what they wanted to hear. So, you may want to basically let them know, you know what, this may not happen automatically. I've done everything I can, right? These amazing, handsome, lovely attorneys in the team, they've done everything they can, but there's still going to be things that need to be done after I am gone. Basically, what's the basics we need to do? Well, somebody's got to get control of the assets, right? Somebody has to get kind of what I call badges of authority. Because if you die, somebody can't wander into the bank or the title company and go, hey, gimme, right? I'm the heir, or I'm my dad's executor. There's going to be more to it than that, and people need to understand that. And of course, we need to make sure that the expenses, the fees, and the taxes are handled. So that means there are certain steps and processes that need to be gone through. Many times, someone passes away, and the first thing people think to do is they will tell all the institutions, the banks, everybody else, this is what's happened, they're dead. I get it, right? You're trying to do everything you need to do. But sometimes there might be checks flying around, and now there's no account anymore for them to go into because the account is frozen. Or there might have been some electronic payments that we were depending upon for the home or something like that, for the mortgage to be paid, and now the account is frozen. Because as soon as the bank finds out, they will freeze the account. Even when a spouse dies, by the way, this often happens, because the account may be associated with one spouse's social security number rather than the survivor's social security number. And it can cause some awkwardness when you're trying to pay your bills, or you're trying to make sure the house doesn't go into foreclosure and there's no available bank accounts. So in your binder, right, what do I do? How do I get control of it? What's supposed to happen? There is a section called a checklist of things to do when a death occurs. Now, obviously, you could predict this already. The first thing we're going to tell them to do is reach out to us, right, and talk to us. We're here to help. We'll walk them through the process. Here's what should be done. Here's what you should start doing. But there are a host of other things, right, that they could at least see and go, okay, right, even if it takes 4 weeks out to get an appointment or whatever, I don't have to panic in the meantime. There are a number of things that you could point out to them. So you may want to say, look, in my binder, there are some other things that you could look at about some steps to take after I am gone. But obviously the main thing is, right, unfortunately, sometimes people try to do it themselves, and I get it. But this is like me trying to put together do-it-yourself assembled furniture. I'm very confident when I start, and by the time I end up, it looks like something that really should have been put in the garbage immediately, because things just tend to go wrong. When we don't know what we're doing, it's very easy for things not to be done correctly. I will have people try to get a tax ID number immediately, and then I say, well, what information did you put in? And they don't know. I don't know, I don't remember. Or they put the wrong name in. Oh, I thought it was the trust and that was the name. Oh, it was a trust? I put in estate. These are all magic words, and we got to be really careful. So, right, there is a limit to trying to just do everything self-help. Okay, so on this then, there are a number of different things that you're trying to make them maybe aware of. Again, this is voluntary on your part, what you'd like them to know. Basically, the bottom line is whoever's in charge needs to understand, and maybe the other kids too, guys, I need you to be patient with Bob. By the way, there's like 12 Roberts in the audience today, I think. There's quite a few. So I'll just use Bob as an example. So Bob, you're the oldest son, I want you to be patient with him, because this is going to take some time. right? Just support, be there, but understand, generally speaking, the administration, how many of people have you here have been through probate? Okay, and about how long did it take?
A year.
A year?
2 years.
Okay, a couple of years, it depends. It's usually about a year to a year and a half, right? And that can be frustrating for people if they didn't already kind of get that, especially the ones who aren't in charge. They think something nefarious must be going on, right? Maybe Brother Bob has bought a place in Valley, right? And he's siphoning the money off. So it's also a fair amount of effort. So we want people to understand this is why we all want to get along and get together, because your brother's actually kind of doing a pretty fair amount of work, regardless of what we're doing here. And of course, it's going to be some money, right? They got to understand, usually the CPAs, the attorneys, the courts, the publications that may need to be done, these institutions are sympathetic and understanding, but they also like eating, right? So they're all going to want some money out of the estate. So with a will, right, sometimes I will meet with people and they say, well, Mark, Dad has a will. What are you talking about, a probate? Why would we need to do a probate? There's a will here. And having that understanding with them that if things are stuck in your name, regardless of whether you have a will or not, it's stuck in your name. We will have to do a probate because your name doesn't automatically come off of your bank account or your brokerage account or the deed to your home. You can't reach up like a zombie movie out of the grave and start signing transfer documents. Instead, they'll need to get some magic pieces of paper, those badges of authority called letters testamentary, and those can only be obtained through the dreaded word probate. So if you have a will, right, it's okay, right? No judgment, have my clients do a will. I advise many of my clients, a will is going to work fine. But people should understand down the road, look, guys, this is the plan. There's going to be some court stuff that probably needs to be taken care of down the road. Many of you have living trusts, and the goal there is, of course, to avoid probate, but that doesn't mean you can reach up out of the grave and sign documents. We need to put together magic pieces of paper in the office. We can wave to the courthouse as we drive on by, but we still have paperwork that needs to be done and administration that needs to happen. So oftentimes I will meet with clients, and one thing I'd encourage you, if possible, to let your agent under the power of attorney know. When you die, the power of attorney is also no longer effective. And I will meet with kids and they're like, well, Mark, I've already used the power of attorney and I've done this and that and the other, and I'm like, whoa, you weren't supposed to do that. Yes.
What about the spouse?
Even if it's the surviving spouse, if it's stuck in your name, in all likelihood, there's going to be a process that needs to happen.
But if her name's on it.
If her name is on the account, it's probably joint with right of survivorship. Great question. Okay, so that's the main thing, right? Let them know, look, kind of that power of attorney is only supposed to be able to have them represent you for things you could do. If you're dead, you are not doing too much, at least that we know about here on this earthly mortal coil, right? So they can't use that anymore after you're gone. What could I do, Mark? I can't tell them all this information. What am I supposed to tell them? This is too much. They don't want to hear it. What do you know? It's possible that Rieberg Law Group actually has seminars. Typically, we do it once a year. What do I do when a loved one dies? And I would encourage you to consider bringing along that executor or the child or whoever you name. Say, I need you to come to this. Mom, I don't want to come. I don't want to think about your death. Okay, then there's no Christmas present for you. Right? Or I'll buy you dinner. I'll buy you lunch upstairs. I realize you have to listen to a boring attorney give a boring speech for an hour or so, but I will make it up to you. But the bottom line is, right, there are ways to get more information. You can find it online if necessary. Our website is a great resource too. Yeah.
Just a little confused about accounts that are, say, possibly in my name, and if I pass away, doesn't it go, I mean, I have a list of beneficiaries.
Yeah.
Doesn't it
Yeah,
pass to the
forgive me.
beneficiaries go?
This is a similar question that I failed to make clear. So let me back up a second. The issue is, Mark, wait a minute, I've got beneficiaries on my accounts, or it's a joint account with someone else. Are you telling me that has to go through probate? And the answer is another question. If you have a beneficiary on your account, when you die, is that account stuck in your name? No, right? Because they fill out the beneficiary paperwork and that transfers over to them. So that is not stuck in your name. If you have a joint account, joint with right of survivorship, is that stuck in your name? No, because by operation of joint with right of survivorship, they can put together some paperwork. It's not. What I'm talking about, things stuck in your name, would be things like a brokerage account that's in your name only, a bank account that's in your name only, or even if you are married, your deed says, right, Bob and Linda, comma, husband and wife. That does not mean it's a joint with right of survivorship home. It means you own half and your spouse owns half. And believe it or not, things will have to occur to get that property over to the surviving spouse. So that's one of those gotchas, okay? By the way, don't immediately run out and start retitling everything, because there are worse things than probate, okay? By far, there are worse things than probate. And you want to talk with your attorney about what they might be, but those things include estate tax, right, that you might be doing badly in that kind of planning. If you start monkeying around with beneficiary designations, people, they die in the wrong order, right, and now that's all messed up. You may have a situation where your daughter goes into bankruptcy and you put all these things as beneficiary to her, or she's on government benefits, and you didn't do the planning, you just put people's names on it. Oops, situation. I'm going to leave everything to my daughter by beneficiary designation, Mark, so there will be no probate. She'll share the money with her siblings. That's a bit of an issue. Daughter may not want to do it. I deserve it. Dad loved me more, right? I think I should get that money. But even if she's a good daughter, oh gosh, I'm surprised Dad did this. I'll try to get it to you. Again, what do we have? One, we have how does she make the gift to them, because if she gives them more than $18,000 per person per year, there is a gift tax return that needs to be filed with the federal government, and she's burning up some of her own estate tax exemption for her life, but she may not have time to dribble the money out because maybe she's in a divorce. And do you think angry ex-spouse is going to go, yeah, that obviously was not meant for you. That was meant for your siblings. Or she had a car accident on the way to the hospital, right? Or she's in a bankruptcy. So there's a lot that can go wrong just by trying to avoid probate, okay? We're not directly on that topic today, so that'll have to be the tidbit. You either see us or come back for another seminar, and we get into more of those kinds of things. Yes, sir?
I saw a new caption on one of my accounts, option, TOD.
Yeah,
Transfer on death.
correct.
How does that differ from right of survivorship?
Transfer on death is a different process in that if you die, it goes to that person. Transfer on death. It's another way to say a beneficiary designation. If a joint account means that if they die, you get the whole account, right? TOD means if they die and it's transfer on death to them, they're just not around, right? So it's a completely different way of doing that. Joint means you're giving them ownership property rights right now, this minute. TOD means they've got to kill you first, right? Then they get the money. There's laws against that, by the way, don't worry. So, but joint with private survivorship, remember all I just mentioned about the issues if someone's a creditor, they have predators in their life, like angry ex-spouse, they're in a bankruptcy. If you make that joint with private survivorship with that person, how much is theirs? We've had a situation where there was a kid driving a motorcycle and his parents were on his accounts as joint holders. And they put him on their accounts. And there was thousands of dollars spent tracing where the money came from to put into the accounts. Because the other side said, well, that's child's money. He's a joint owner. So those are, things you want to be careful about. Titling is very important. Okay, number 3, the next slide. Wow, Lori's already ahead of me. And that is, we want to make sure that your kids understand that there may be an estate tax when you pass away. They need to be prepared for that. Now, this is a long discussion. We're just going to deal with the highlights, lowlights here, okay? Both the federal government and Washington State have an estate tax, okay? But they work kind of like a limbo bar or a get-out-of-tax-free card. Anything below the limbo bar, anything below the number it says on the tax-free card does not get taxed when you die. But anything above it could get taxed. Now, there's a lot of ways if you're married, right? We're talking that you could get a marital deduction. There's a lot of different ways we wouldn't need to worry about first spouse to die. But we're really worried when the second spouse passes away, and there is planning we can do when you're both around, right? Or when you're around to try to think about, are we worried about this or not? So the limbo bars, anything above the limbo bars get taxed. Now the federal exemption number is currently very high. It is 13.61 million. Next year, it will rise to 13.99 million. And my question is, couldn't they have made my life a little bit easier and just say 14 million? Really? How much money are they going to lose by the additional 10,000? But anyway, 13.99 million. Anything above that number would be taxed at 40% after you're gone. Most of us don't need to worry about that. There is a tiny little cloud in the distant horizon, and that is that on January 1st of 2026, the provisions that doubled the exemption amount on the federal level sunset. And that means we go bye-bye, and they go back and they divide essentially in half. That is if Congress does nothing. Now, we've got President Republican next year, we've got Congress that's Republican. Probably they will do another act to extend that out further, but there's no guarantees, right? The last time the Republicans were doing a heck of a lot, they couldn't figure out who the speaker was supposed to be, who the leader of the party was going to be. So it's a little odd. I can't guarantee you anything. The state level, though, very different. The state exemption, the get out of tax-free card. If the federal exemption level is like, the Empire State Building, right? It's that high. The Washington State exemption amount is like, I don't know, a small little shrub in your yard. It's 2.193 million. Again, couldn't they have just made it 2.2 or something? In my sleep, I murmur 2.193. My wife wonders why I keep saying 2.193. Because that is the exemption amount. It used to rise with cost of living, but because of a technicality, the Department of Revenue is refusing to have it go up anymore. This has been for the last 5-6 years. The index for cost of living in Washington changed a city or two, and as a result, they're like, oops, the index isn't there. We have more money now. This money, by the way, is used to fund the Education Trust Fund. That is the fund that goes to pay for education, which not coincidentally was the reason that the legislature in Washington was held in contempt of court by the Washington State Supreme Court some years back. So as far as I can tell, that number probably is not going to go up. And we need to plan for that, right? Anything above that number, the first million over 2.193, for my sake, let's call it 2.2. The first million over, 10% tax. The next million over, 14% tax. The next million over, 15. Goes all the way up to 20%. And that is not a hard number to come to anymore, right? You're home, you bought it for this amount and you didn't notice, but now it's worth this. Your retirement accounts, they're worth hopefully more, and other things. Maybe there's some life insurance, who knows? Pretty soon, it's pretty easy to get there. So while you're around, make sure you have the understanding, the meeting with the attorneys, accountants, other people. Hey, what's going on? What do we need to do? There are some pretty effective tools. We can at least double the numbers, make sure each of you and your spouse get your own exemption. That way, right, first spouse dies, here's my tax-free card. Second spouse dies, here's the tax-free card. Bad planning, like leaving everything to one spouse by beneficiary designation, means you use the marital deduction, no tax, but now it is all with the survivor, and we threw away one of our exemptions. When the survivor dies, it's all in their name. So you want to let them know as well that if we're over this kind of number, their best friend is going to be a CPA, an accountant, because an estate tax return will need to be filed within 9 months. And the government, I know this will shock you, they do not take IOUs, right? They like actual liquid money when you have a tax debt. So at 9 months, in many cases, very firm deadline. Yes?
These estate numbers are per person?
It's per person, yes. If with the right planning, you're married, I assume to only one person, you're married, right? And each of you get that with the right planning. But it's critical we have the right estate planning with that. Okay, so let them know that, okay? I would tell you, I met with a client yesterday. They had about 5.2 million. They were single. And 5.2 million, quick math, that's 3 million over the 2.193. 100,000 for the first million over, 140,000 for the next million, 150,000 for the next million. A $5.2 million estate, when they pass, will lead to 390,000-ish or so of estate tax. This can be a shock to people, right? Because that doesn't seem like a realistic way that life should be, but that is the way it is right now. Okay, we're going to need to roll forward. Forgive me. If you have questions on that, I'll be around after, but mostly, maybe you make an appointment with us or come to another meeting, another seminar. Number 4, what do I want my kids to know about what my plan says? Do I really want to tell them what my plan says? Why would I do that? That's very personal. I'm still around. Well, again, we're heading into what you think is wise, given your beneficiaries, your kids, your executor. Generally speaking, right, we have different types of things and you may want to let people know about at least some things while you're living. The first thing are called personal effects. These are the things in your home that aren't nailed down in the house or the garage. Jewelry, artwork, heirlooms, collections, the guns, the Harley, the Corvette, the plane, they're personal effects. And you can, in your binder, there should be a personal effects distribution list that you say, I want to make sure that these things go to these particular people. Now don't worry, your trust or your will is going to say, my personal effects go in equal shares to my kids, or my personal effects go to, right, wherever my executor wants them to go. We talked about that in your meeting. But there could be some items that are so valuable, so personal, and you think, I need to make sure that this goes to that person. I had a woman who, her grandmother had left her an 8-carat diamond ring, and she had 2 daughters. And at the time, she'd had it appraised for, and it was $100,000. I looked up this morning what an 8-carat diamond ring would be, right when my secretary came in and thought, oh good, Christmas is coming. And so I was looking it up. It's somewhere between about $50,000 and $750,000 of value, depending upon quality. Now, if that woman died, and she has 2 daughters, and they know where the jewelry box is, right? We're gonna have a scene out of chaos, right? They will be tripping one another. Mom's gasping for breath downstairs. Can someone call 911? Both daughters are running into the house to get the 8-carat diamond ring. There could also be sometimes people that I want my Mustang to go here. I want, you've got to make sure. Shakespeare could get away with saying, I want my second best bed to go to my wife, but I don't think any of you are Shakespeare, and even he didn't write well when he put that in his will. So if you do fill out the personal effects distribution list, I need you to be really specific. If that woman with the 8-carat ring just said, I leave my ring to, you know there's going to be a fight. So be very specific about what it is. And then you'll notice on that page, there's a place for you to sign and date. You don't have to have it witnessed or notarized. You may, again, want to let your kids know, I've decided this, right? Now, I will have people go, well, Mark, I've got it figured out. I went through the whole house and I put little sticky notes on everything, right? I want that to go here. Now mom's down at the bottom of the stairs gasping for someone to call 911, and meanwhile, son is like, switching all the things around. So, or writing their own. That's mom's handwriting. So you want to, only for the things you think you care deeply about, people may fight about, you promise to somebody. Okay? So go to the binder, take a look at that. If you're married, you're going to see one that has both names, both you and your spouse. That's for your stuff together, right? We bought this together, it's our stuff together. But you may each have things from your own family. That's my dad's watch. That's my mom's engagement ring. That is my dad's medals, right? Whatever. There's places often for each of you to consider on that. It basically says, I want these to go here, unless my spouse really throws a fit, right? My wife, for example, has a lot of knitting materials. She's learned how to knit. And I'm wearing a knit cap if you see me. It's sort of it's a hideous yellow cap that I don't tell anyone. Hideous, yes, I absolutely adore it. And I will wear that all the time. I am amazed how cold my head gets, even though I have this full head of hair. Wait a minute. So, if she dies, I am not going to want her knitting materials, right? And she has a friend, and I know she's going to say, Mark, I want my friend to have those things. It's that kind of thing. Maybe it's a motorcycle, and you're like, I wouldn't get on that, right? So that kind of thing. Yeah.
If something is not designated, it kind of goes to the general pool of assets, and the executor is responsible for.
Generally, it would depend on your will or your trust. There are specific personal effects paragraphs in those, and they will designate. Unless otherwise, specified on a personal effects list, my personal effects are distributed in an equitable fashion among, or my personal representative has the discretion to designate who receives them. By the way, pets are, oddly enough, considered a personal effect. If you have a pet, I would like you to consider letting those in charge know, maybe even a neighbor, somebody even closer, how do I get into the house if there's the pet and I've been taken away to the hospital? 2, who's supposed to be in charge of the pet if you're getting well or you're not getting well? You may want to specify those things. Many times people will put that in their will, but the reality is we don't want the animals sitting in the house for the year it takes for the probate to start, because they're probably going to get pretty hungry by then, right? So you want to let people around you know these types of things. Okay, how much do we want to get into?
I have a question. In terms of the PE list and other things, what's the relation between pen and ink, pen and pencil.
Oh, good point. Yeah, you don't want to put your personal effects distribution list and write it in pencil, because that eraser, which once was our friend, has turned like Judas against us, a tu brute. So we don't want that to happen. You want to put that in pen, right? And if you use it up next time you come and you're like, hey, I've changed my mind, right? Mark, I want you to have a nice sweater, right? Because that dark purple was just, didn't clash, didn't work well. Don't leave anything to me, I'm kidding. I will be disbarred and that would make me sad. So don't do that. But anyone else, yes, put it in pen, thank you. Okay, sometimes people will say how much I left to people, right? You may want to consider discussing why you made the choices you did. You could even consider talking about rough amounts. Many times people will leave some items like an IRA or a 401k to people who don't need a long-term testamentary trust, and they leave more to them that way, and they leave different percentages in the will. Or sometimes people have given away money during life to one child, and right, then their will just says 10% to this child, and everybody gets upset. What happened? Why am I not, right? And unless we have some record or some people understand why you did it, people are very quick to assume money means love, which even in a capitalist culture like ours, they're not exactly the same thing, despite what you see in all the movies and the books about I married my billionaire boyfriend or whatever. It's not exactly the same. So you may want to let people know. I had a dentist and his wife, clients, they're very good people, lovely people, where one son had a few money issues. And then he had more money issues. And then he had even more money issues. And he had more issues. And then he married. And sure, his wife had money issues too. So they were paying everything for this son. And it ran into millions of dollars. So, right, you want to let people know why you're doing certain things. Fortunately, we had a lot of documentation. And there was a lot of explanation. But you know what? He still seemed to think, why didn't he get an equal share when mom and dad died? Shocking. But anyway, you may want to consider that. Okay, I want my kids to know what my plan says, if it's appropriate, right? Sometimes there are specific issues, sometimes you decide intentionally, I think, yeah, I've got kids, they're eldest, middle, youngest, but sometimes it's not a good idea to just say, that's the order of my executors or my agents. You may want to mention why that is. Look, I just want you to know this is why. I met with a gentleman and his wife had passed away. He's starting to have a little bit more difficulty in paying bills, specifically some large tax bills. So it seems like we may want to have one of his kids be a co-trustee with him. Fortunately, daughter and son were in the meeting and we talked about adding a co-trustee to his trust now, and instead of having son, the oldest, to have daughter help instead. And I said, well, here's the reasons why we may want to do this. I want to talk to both of the kids. I said, I want you to think about this. Do you have time? If you're your dad's co-trustee, you're going to need time, T for time. Could be hours, could be more per week, right? Could be a lot of time. We need you to be honest. Of course, I didn't say that. You're not honest, but that's obviously one thing you want from your own. If your eldest is not really always on the level, you don't want them to be chosen. You want organized, over-organized. If they can't, keep their own paperwork in nice, neat stacks and they can't figure out their own lives, there's unpaid bills all over the house, maybe I don't want them in charge of things if I can't do it. And finally, of course, you want them to be responsible. They may be the most responsible person in the world, but if they don't have time to take care of your stuff because they've got their own job, their own family, their own issues, their own whatever, they may not be able to be responsible and take care of your things. So when you're talking to them about why, T for time, H for honest, over-organized, R for responsible, you say, I need a superhero. I need Thor. That's why I chose one versus the other. And at the end of this conversation, son says, he just looked at his sister. He didn't say anything, looked at his sister. I started laughing. Finally, they broke the ice, and he's like, yeah, I think you should do this, sis. Right? If you explain it, oftentimes they get it, right? They've been probably looking for your approval, love, affection, whatever. Sometimes the wrong message can be sent if we just give them silence. Bigger problem is sometimes there is that unequal distribution. It might not be because one child got money during life, but it could be that, hey, you know what? One child needs more, the other child has more. One child has just done really well, the other child has had some health or other kinds of struggles. Sometimes it's really a good idea, if you're determined to leave money differently, to let people know. Kids, this is why I'm leaving your sister half the estate and you two get less. It is not because I don't love you. I'm so proud of you. I love everything about you, but she's going to need the money, right? Having that conversation in advance can help a lot to get people to not be angry, upset, surprised if things aren't what they thought, equal, right? Sometimes you have people getting things and you think, if I give that much money to my son, he's in the middle of a divorce, or he's just bad with money, or he's gone bankrupt, or his wife Bambi, I know there's going to be a problem, right? So sometimes people will put money to a child in a trust, not directly to them. These are called testamentary trusts, meaning you're dead trust, right? Testamentary. After you're gone, they don't get the money directly. It goes into a trust for their benefit. You may, if you're doing that, want to explain, I love you. This is how I'm trying to protect the money that you're getting. It does not have a reflection on who you are. I had a client who insisted that this money go to her son in trust. So he comes in, mom's passed away, I'm talking to him in the meeting. I said, well, he's like, oh, well, you know, okay, so then I just should put the money in my name. No. Your mom wanted you to have this in a testamentary trust. Here's how it works. You can use the money for your benefit, but it is not yours directly. He was flabbergasted, absolutely gobsmacked, dumbstruck, you name it. Could not believe that that's what his mom had done, right? And it might have been helpful for her to explain that to him, because I'm thinking, well, I think your mom did it just to help and protect you. But oddly enough, coming from my mouth, it was not as effective, right? So he was not necessarily buying it. If there is a family business and you're determined to leave it to one person or the other, that would definitely be a conversation to have with the kids. Here's why this is happening. You probably need to talk with your attorneys, because we may have to figure out how do we try to at least attempt to make things fair and equitable among all the kids. A biggie is disinheritance, I'm sorry to say. You may not want to raise that one, but now and then, maybe it's appropriate. Sometimes kids divorce from their families, and they don't show up again till 20, 30 years later when you're on your deathbed or you've died. Now suddenly, oh, I loved mom more than all of you, right? I was the only one who understood mom really. And it's amazing how people can have different memories about what happened. So you may want to have this conversation, even if not to the person you're disinheriting. You may want to let others in the family know. And there is some places in your binder. One of them is called instructions to trustees, but I would recommend you consider filling out your own letter or paper that explains why you did this, right? Here's why I came to the painful decision not to include my son, Bob, in my plan, right? Bob divorced the family effectively 13, 14, 28 years ago. Bob has had nothing to do with this since. and I want to have the, the money and my things go to the children of helping. Put that in your own handwriting, don't type it out and sign it, because then people are gonna go, oh, your mom didn't know what she was signing, you just slipped that piece of paper in front of her, right? It's amazing, I had a woman, she died very unexpectedly on a trip in Mexico, 3 kids, and one of the kids had gotten a lot of money during life. He was a vineyard owner, and amazingly enough, you probably know the way to make a lot of money in the winery business is to start with way more money, because you're going to lose it all, so you're left with just a lot of money. And he continued to lose money with the vineyard. Apparently good wine. I've actually had the wine later and went, oh, look at that. But he ended up suing the estate. Why didn't he get a fair share? And we put down everywhere we could, this is why. And they did make that allegation, right? Well, somebody just typed that up, and that's why Mom signed it. She didn't know what she was signing, even though I had notes galore and everything else. So, did you have a question?
Yeah, you need to be also very careful when you make those declarations that you monitor whether that situation still exists.
Yes, there is a mistake of fact, right, where your kids say, oh, so-and-so's dead or something. Charlie died years ago, Mom. So, again, all of this, just be sensitive to your own situation.
Okay.
This isn't a you must do it.
No, I'm saying it because your family may be in a situation with a particular child at one point that
Right.
completely changes, and if you haven't taken it out of your will, damage to that next generation.
That could be. Obviously, all of these, the issue is, well, things can change, right? You put one thing in your will, or you write these letters, and now things change later. We all hope for the better. And your will can only reflect what you were doing at the time, the same as these letters. You do have to understand when you're doing the disinheritance or unequal distributions, that's already controversial. People have a way of equating, I should get my share and it should be equal regardless. So you have to be very sensitive and understand things may change later on.
We were almost to that point
Yeah.
for the scenario, and things did flip around, and it's happened within the last couple of months.
That's in a good way.
Yeah, so we didn't
Good.
make the appointment
Yeah.
to talk about changing the will.
Okay. Well,
and then-
I'm sad
and
that
then-
you didn't
but
come in
then
and see me. I'm glad for you. Fine. Get your family over me.
We've also been victim of the other end of it, where
Yeah.
in my mother's will, it said something about forgiving a loan. We didn't have a loan. So
Oh,
it
wow.
looked-
Okay, yeah.
To me, it was a shame thing, because it looked, there's 8 kids in our family.
Yeah, often in our document, the question is like there's a loan or something, and our documents will also have, the person will keep a ledger somewhere, that kind of thing. It won't just put a number. Life can be flexible, right? And so we would recommend, usually people come back every 3, 4, 5 years when circumstances change. Okay, we are close to being out of time. I want to be sensitive to your timing. You say, okay, Mark, that's all fine and good. That's fine, really, I don't want to do that. Or you say, well, you know what, this sounds reasonable. Maybe I should bring my kids and just have a meeting and talk about all these kinds of things, right? Where there's a semi-neutral observer participant there. You may want to consider, like, you prepare the ground. Right, actually schedule a meeting with the kids. You could even have, if you wanted, your attorney there to kind of explain what's going on and why. Of course, you need to be prepared. Everybody should come prepared to listen, 2 ears, 1 mouth, where we don't get into fights. These can be very contentious issues, right? If people didn't never hear about this before. You may need, if you're going to do something like this, you may want to consider sharing your values, sharing the reasons why you did these things. And of course, at the bottom line here, you may want another person there to kind of help, to make sure that emotions or other things don't get completely out of control. There are, actually some companies, the advisors, this is what they do all the time, right? They help the family create kind of the vision plan and the values plan, and here's why we're doing it, and they do it generations. You may not need all that, but it may, in some cases, you could consider, hey, I don't want them just to know more, I want them to be comfortable, right? To kind of know the big picture plan, to know here's the attorneys that can help. It doesn't have to be all about the sensitive stuff. It could just be, hey, we want them to know, what's it gonna look like? What do we have? What is it gonna take? What's happening? And we can't do those meetings. I think you've been warned, attorneys are coin operated, right? So we would, insert coin, we'll move around for an hour or two, and then we'll shut down at the end of the hour or two, because this is the amount, right? So, but that is an option for you, okay? You're not all on your own. Okay, now, some people, they just want to know more. Mark, that was a nice attempt, but I have way more questions than answers from you. Thank you very much, right? Way to go. If you need more information, we do have more information. We've got the newsletters. If you haven't signed up for those, you're not getting them. We're sending those out to clients. You can say, hey, I need a newsletter. Here's my email address. And then you may then need to check your junk or spam filter, because that newsletter is going to have things like money and death and taxes in it. Which, right, you've set your spam filter to go, I wanted to hear nothing about those terms. So you may need to look and then let that come through. Generally, we'll give you updates on the big picture issues. So that may be one thing. Our website has a number of different kinds of pieces of information along with seminars. Believe it or not, there is an incredible internet star that has developed. One of the top people on YouTube, I have been told. It's me, I'm on YouTube. I give like a 13-minute or so presentation on estate planning. There's one on how to prepare your meeting. That one has not done well. That one has not done well at all. I think maybe 2 people have seen it, Corey and me. But that one's there as well. There are other videos, things like that. You're like, I'm not really a video kind of guy. I'd rather watch, I don't know, The Return of the Mandalorian or whatever is going on. I don't want to watch a planner. So we actually have live seminars, much like the one you're attending as we speak. There probably will be cookies. If there's nothing else to get you back in here, coffee. There's at least some friendly faces in here. I accept myself, of course. And but we have what's tools, tips, tricks, and traps. That's one of our sessions about general estate planning. We have a Prepare to Die seminar, which is what to do kind of if death is looking pretty imminent. Then, what do I do when a loved one dies? There's quite a few that we do, and the announcements for those would be in our newsletter typically, or I believe on our website. Or, horror of horrors, you could actually request a consultation, a meeting, come in and talk to us to be more about your situation. Mark, what should I do when I'm titling things? Mark, I've got a joint account, do I need to change that? Right, Mark, I have some insurance, or here's a specific information about family and good news or bad news, those kinds of things. Your attorney can look at your plan and go, oh, here's how we can work with that, here's what we can do with that information. All right, any questions for me? How bad did I? Oh, only 3 minutes over. That's not bad, right? It was said of Queen Victoria, she would basically tell the Archbishop of Canterbury when they come and he'd do a sermon, she would say, that was a fantastic sermon. Those were always the really short ones, right? She only would grade it depending upon length. Did you have a question way in the back?
Yeah. We have a living trust, and the checks and all our financials, everything is our names that says trust in it. The wife is worried that if we should both go instant, how are bills going to get paid right away? So how can we get, because probate and
Yeah.
although ours wouldn't be probated. But how can they get access at some ready cash to, if we were on a trip? We gotta get the bodies back, that's 80 grand.
Yeah.
You know, whatever. So how would they get at some cash to write checks or pay
Like
some
for
bills that might
really
be...
short-term emergency.
Yeah.
Are you the wife?
I am
What is your, just first name, what is your name?
Debbie.
Okay, Debbie, really? So, the bottom line is sometimes people will have a minor account that they have joint regret of survivorship with one of the kids, or they make the kid have the ability to sign on that account. It's not a joint account, but you can give that person the authority to sign on it. Generally speaking, though, with the living trust, it does not take very long to get the next in line in charge of the money and things like that. It may take, a few weeks, maybe, right, that kind of thing.
No.
So, I guess if your bodies are there in, Morocco waiting to come back, that's a long time. But generally, with the living trust, it shouldn't be too bad. And you gotta be
Get travel
careful with the
insurance, they
title, of
appropriate your
course.
bodies.
Yeah.
It's part of
Once
it.
we died, when I probated the one estate that I did, I couldn't pay any bills.
Yeah.
So you gotta be careful what you pay and what you don't,
Yes, that is an absolute truth, absolutely. You want to be sure you understand if your child isn't just paying every bill that comes in. Some bills you should pay, other bills you should wait for a creditor claims process, right, before you pay them. Because there could be fraud, right? And somebody just, hey, here's a bill, send money to, and oh, okay, oops, that was wrong. I think our government, Washington State did that, right, with a number of unemployment claims. Allegedly, I say to the camera. So, you may want to, be careful, again, remember, these are general things we're talking about, not particularly specifics on what happens after you're gone. Okay, since we're running a little late on time, I'll just leave a quick little note. Joe Strong in his will wrote, "My will is easy to decide. I have nothing to divide." All right, thank you very much for your time and attention. And I will be here for questions if you have them. Again, remember, somebody's overhearing it all, it may not be terribly confidential. I believe we have a gentleman that's standing by in case you want to have a meeting with us.
Oh, no,